a lot of bright lights, my God.
Get cutaways with Corey. Is there any way we can swap the mic so we can see it? Yes, no.
Not really. Unless we do
No,
that.
it needs to point towards you. That's it. That's it.
Okay, we're going to get started in just a few seconds. If anybody's not ready, let me know.
We're not ready. We're not ready.
Okay,
We're working on it.
no problem.
Can you just wait 1 moment and like come around?
Yeah. Yeah.
I am not ready.
Do you want your tripod?
Yes.
Before we get started, Vanessa, what's the most important thing right now? You tell me, is it straight? Okay. Take a lesson, Charles. Okay, everybody ready or no? Okay, it sounds like everybody is ready. Okay, most of you folks know how I do this. I'm going to make a short statement and then take a few questions. Please try and respect each other when you ask the individual questions. So good morning, I'm Steve Wolfson. I'm the Las Vegas Clark County District Attorney. This morning, Dwayne Keith Davis made his first court appearance here in Las Vegas pursuant to the indictment, which was returned last week, charging Mr. Davis with open murder with use of a deadly weapon with the gang enhancement. I want to say first off that Mr. Davis enjoys, like any other person in this country charged with a crime, the presumption of innocence. Today, he is presumed innocent until a court proceeding, a criminal justice system, proves his guilt. Today was the scheduled arraignment, but he can't be arraigned until he has a lawyer. Mr. Davis announced that he has retained a lawyer. I believe his name is Edie, spelled E-D-I, Fall, F-A-L-L, who is a lawyer out of California, is my understanding. Lawyer Fall couldn't be here today, so Mr. Davis asked for a 2-week continuance. That's why the judge put the case over, I believe, until October 19th for his arraignment. That is when he will formally enter a plea of not guilty, I believe, and then at that point, the judge will set a date for jury trial. So that's what occurred today in court. Nothing will occur in the next couple of weeks until the next court appearance when his lawyer appears. Mr. Davis is being held on no bail. That no bail status will continue at least until his next court appearance. We will continue to ask for a no bail setting because we believe under Nevada law and the evidence in this case that the proof is evident and the presumption is great that he will be convicted of first-degree murder, and that allows us to ask for a no bail setting. I'll take some questions now.
Steve, what does it mean after so many months of work from your office to see him in court today?
Well, he's no different than any other defendant. I mean, we had a feeling this day was coming in the recent history based upon some of the events that have occurred in the last few years and few months. I like to see the person in person because on these cases, it's usually me that makes the ultimate decision on how to proceed. So I like to look at a person who's being charged with a crime in such a high-profile case. I like to look at their mannerisms. I like to look at their demeanor. I like to listen to them and kind of get a feel for their attitude. I understand that the day of his arrest, they were speaking with him, but I don't have anything further to say other than that.
Is there any coordination with LA about Victoria's CIG?
I'm not going to comment on anything involving that other matter.
Elise Preston, CBS News. This is such a high-profile case, 27 years in the making. Can you talk about how that could impact the legal process moving forward?
Well, it's a cold case. It's been lingering for 27 years, but I felt there was sufficient legally admissible evidence to move forward. That's why we presented it to a grand jury. The grand jury agreed that there was probable cause to return an indictment. But this case is like no other case. In a court of law, we have to present sufficient legal evidence to hopefully prove his guilt beyond a reasonable doubt. Any case that's 27 years old sometimes presents some challenges, but we feel very confident that the criminal justice system will work in this case.
Mr. Wolfson,
Is there any
many
reason
people
to
have
fear
wondered
for
why did it
safety
take
with
so
that
long?
gang affiliation?
Whose safety?
Davis's safety while in custody?
I don't know. I don't know anything about his safety and his contacts or his relationships with people from 27 years ago. I don't have any information regarding that.
Steve, I spoke to Tupac Shakur's brother yesterday. He says he feels that this case wouldn't have gone without a breakthrough for 27 years if Tupac had been a white man. Would this have been solved more quickly if Tupac had been white?
We don't look at the color of a person's skin. We have a number of cold cases that excellent detectives work on every single day. And whether the person is white, black, red, blue, or green, we move based upon evidence and what we can present in a court of law.
Steve, a lot of people have said, why did this take so long, especially in the last few years? Mr. Davis was very vocal about his involvement. Is there a simple answer to that question?
The simple answer is that this is an important case. We wanted to make sure we get it right. We wanted to make sure we had legally admissible evidence. We wanted to make sure that we felt comfortable that we had sufficient legal evidence. You know, if you're going to charge a person with murder, he has a right to believe that the system would only bring charges if there was sufficient legal evidence. So we waited until the point in time when we had that degree of evidence to move forward.
One of the things from the PPD in recent years is that he has said that he has terminal cancer, he has cancer, he's very unwell. Is that playing any role in this criminal procedure?
I've heard the same comments as well, some of the statements he's made to the media. I don't know his current medical condition. I'm not going to speak to whether he's still suffering from cancer or not.
Do you think that the trial perhaps will happen quicker because of the high profile of it, or when do you anticipate the trial likely?
Well, in a couple of weeks, when he's formally arraigned, he has a right to invoke the Speedy Trial Act, which means setting a trial within 60 days, or he can waive that right to a speedy trial, and then the trial would be set off into next year. We have to wait to see at the arraignment what he chooses to do. Anybody else? We're good, thank you.
Peter?